Good morning, this is your Kelso Report for Thursday, March 22nd, and I'm your host, Clark Kelso. The Supreme Court had another busy day in issuing important decisions in the area of environmental law and two habeas corpus cases. We also have the Ninth Circuit decision involving gender discrimination, discovery sanctions, and a tax case, and then one case involving criminal procedure, right to jury trial under state law. We begin with the United States Supreme Court and its environmental law case. When the Environmental Protection Agency determines that there is a violation of the Clean Water Act, it can either issue a compliance order or it can initiate an enforcement action. In Sackett v. EPA, the agency determined that the owners of a residential lot were in violation of the act because there were navigable waters supposedly on their residential property, and a construction project on the property was going to discharge pollutants into those waters. The property owners received a compliance order from the EPA, which stated that their residential lot contained navigable waters and their project violated the act. The property owners filed an action in district court challenging the compliance order under the Administrative Procedure Act. The government argued that there was no jurisdiction under the APA, either because the APA did not apply to a pre-enforcement compliance order, since it arguably was not final agency action, or because the Clean Water Act's provisions preclude judicial review of compliance orders. The District Court of the Ninth Circuit agreed with the government and dismissed for lack of jurisdiction, but the Supreme Court unanimously reversed. The court first concluded that a compliance order does satisfy the standards for being final agency action, and such an order was therefore subject to review under the terms of the APA. Certainly, from the perspective of someone subject to such an order, it sure looks like final action. Second, the court held that the Clean Water Act did not expressly or impliedly preclude review of compliance orders under the APA. The government's arguments to the contrary were fairly weak, essentially amounting to assertions that the targets of compliance orders just needed to wait for an enforcement action before trying to get judicial review of EPA's decision-making. But as Justice Scalia noted in closing his opinion for the court, quote, "There is no reason to think that the Clean Water Act was uniquely designed to enable the strong-arming of regulated parties into voluntary compliance without the opportunity for judicial review," close quote. Next we have the first of two very important related decisions involving habeas corpus. The first, Missouri v. Fry, both opinions by Justice Kennedy, with Scalia in dissent, leading the dissents in both cases. In Missouri v. Fry, the defendant was charged with driving with a revoked license for the fourth time, which exposed the defendant to a 4-year prison sentence. The prosecutor communicated to his counsel some alternative plea bargains, one of which gave the defendant the opportunity to plead guilty to a misdemeanor with only a 90-day jail term. Counsel failed to communicate the plea offer to his client, and the offer lapsed. The defendant ultimately pled guilty without a plea agreement and was sentenced to 3 years in prison. The defendant's habeas petition alleged ineffective assistance of counsel because of the failure to communicate the plea offer. On post-conviction review in state court, the Missouri Court of Appeals held that there had indeed been ineffective assistance of counsel. The Supreme Court, in a close 5-4 decision, agreed that counsel's failure timely to communicate the favorable offer constituted ineffective assistance of counsel. Justice Scalia, in dissent, complained that the majority, quote, "today opens a whole new field of constitutionalized criminal procedure, plea bargaining law," close quote. Well, while that is certainly true, given that some 95% of criminal cases are resolved by plea bargain, it strikes me, and it obviously struck the majority, that having effective assistance of counsel during plea bargaining is a pretty important right as a practical matter, and now as a legal matter. The court remanded to the Missouri courts for a determination of whether counsel's failure was prejudicial. Now that actually will be a close question on remand, because before the preliminary hearing at which the plea deal might have been acted on by the court, The defendant was arrested again for driving with a revoked license, and it is possible that the prosecution would have withdrawn the deal, or the court may not have accepted it. Since those issues implicate state law and practice regarding plea offers, the court decided to give the Missouri courts the first crack at resolving the prejudice question. In the second case, Lafler versus Cooper, it also dealt with ineffective assistance of counsel in the plea bargain context. This time, the defendant rejected a favorable plea bargain on the advice of counsel, advice that turned out to be seriously mistaken. Simply gave his client bad advice about the likely consequences of going to trial, whether he was likely to be found guilty. After the plea offer had been rejected, there was a jury trial. The defendant was found guilty, and he received a much harsher sentence than that offered in the rejected plea bargain. As the case came to the Supreme Court, both parties agreed that the counsel's advice fell below the standard of adequate assistance of counsel guaranteed by the Sixth Amendment. So the only issue was whether there was prejudice, and if so, the remedy. On the issue of prejudice, the court held that the petitioner would need to show that, but for the ineffective advice, there is a reasonable probability that the plea offer would have been presented to the court, that the court would have accepted its terms, and that the conviction or sentence under the offer's terms would have been less severe than the actual judgment and sentence imposed. If the petitioner successfully demonstrates prejudice, and if the only difference between the plea offer and the conviction is the length of the sentence, the district court can order the defendant to be resentenced in accordance with the plea deal. However, if the plea involves something more complicated, such as a plea that involved dropping certain charges altogether, the proper remedy is to require the state to re-offer the plea deal, and then the state trial court can exercise its discretion in determining whether to vacate the convictions and resentence pursuant to the plea agreement, to vacate only some of the convictions and resentence accordingly, or to leave the convictions and sentence from trial undisturbed. There's going to be a lot of open questions here for courts dealing with these type of new habeas claims. There's going to be a lot of law developing in this area over the next several years. Next, we turn to a Ninth Circuit case involving gender discrimination. Title IX of the Education Amendments of 1972 bars gender-based discrimination by federally funded educational institutions. It provides that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program receiving federal financial assistance. Well, in Imeldi versus University of Oregon, a split panel of the Ninth Circuit addressed itself to the issue of exactly what a plaintiff has to show to state a claim for gender-based retaliation under Title IX. Adopting the same analytic framework that's now used in Title VII employment discrimination cases, the majority held that a plaintiff who lacks direct evidence of retaliation must first make out a prima facie case of retaliation by showing A, that he or she was engaged in protected activity, B, they suffered an adverse action, and C, there was a causal link between those two. As in a Title VII case, once a plaintiff has made the threshold prima facie showing, the defendant must articulate a legitimate non-retaliatory reason for the challenged action. If the defendant does so, the plaintiff must then show that the reason is pretextual, either directly by persuading the court that a discriminatory reason more likely motivated the employer, or indirectly by showing that the employer's proffered explanation is unworthy of credence. On the facts presented in the case, the court held that the district court should not have granted summary judgment to the university, and that the plaintiff satisfactorily demonstrated that she was engaged in protected activity, she suffered an adverse action, and that there were remaining disputed facts regarding the university's explanation for its actions. The court sent the case back to the trial court for further proceedings. Next from the Ninth Circuit, we have a case involving discovery sanctions. Not a happy case, in my judgment. The Ninth Circuit reaffirmed its rule that if a discovery sanction amounts to dismissal of an entire claim, the district court is required to consider whether the claim noncompliance involved willfulness, fault, or bad faith before ordering the sanction. This issue arose in R&R Sales versus Insurance Company of Pennsylvania, which was an insurance coverage and bad faith case. As part of its bad faith claim, the plaintiff asserted it was entitled to attorney's fees and punitive damages. Now, as I'm sure you all recall, pursuant to Federal Rule of Civil Procedure 26, the plaintiff has an obligation to make certain initial disclosures to the defendant without waiting for a discovery request, including a computation of each category of damages claimed, and must make available for inspection and copying the documents or other evidentiary material for those damages claims unless they're privileged. The plaintiff was initially claiming $350,000 in attorney fees, which was increased to $450,000 as the trial date approached. Yet the plaintiff did not turn over or make available for inspection any of the underlying attorney fee invoices, notwithstanding Rule 26, nor the defendant's repeated requests for the information. Instead, plaintiff's counsel repeatedly promised to turn the documents over, but then found excuse after excuse for why that had not been done, stretching over a 6-month period. Just 1 week before trial, the defendant paid off the entire amount of the outstanding insurance claim, which mooted out everything except the attorney fees request. Defendants then made a motion in limine to exclude any evidence regarding attorney fees because of the noncompliance with Rule 26, which the district court granted. And then the district court granted defendant's motion to strike the punitive damage request, since, absent the attorney fee award, there were going to be no compensatory damages on which to premise the punitive damage award. Now, it seemed to me that the plaintiff's counsel got exactly what he deserved for his dilatory noncompliance. But the Ninth Circuit reversed, because the district court had not made specific findings regarding the willfulness, fault, or bad faith of the plaintiff's counsel and their noncompliance. So it remanded to the district court, where my guess is the district court will go ahead and make those findings. Counsel should have made the disclosures required by Rule 26 and resisted. Counsel should have made the disclosures and should have resisted the temptation to try to game the litigation system and jerk the defendant around, which is what appears to me happened. Ninth Circuit's next case is a tax case. Under the Internal Revenue Service Code, certain eligible corporations may elect S corporation status, thereby acting as pass-through entities for federal taxation purposes. The rules governing eligibility to elect S corporation status restrict various attributes those corporations may have, including the number of shareholders, the classes of stock issued, and the types of shareholders. The single question presented to the Ninth Circuit in Taproot Administrative Services versus IRS was whether a corporate taxpayer is ineligible for S corporation status and therefore must be taxed as a C corporation because its sole shareholder was a custodial Roth individual retirement account. The company argued that a Roth IRA cannot be distinguished from its individual owner under a reasonable interpretation of the governing statute, and therefore the company satisfied the S corporation requirements. The tax court found against the company, and the Ninth Circuit affirmed. The key issue here was whether the Roth IRA account could be considered an, quote, individual, close quote, for purposes of the S corporation requirements. Giving appropriate deference to the determination of the tax court, the Ninth Circuit held that an account cannot be an individual. Individual refers to people and not accounts, and that there was no basis for treating the account as indistinguishable from the owner of the account, such that the Roth IRA account could stand in as an individual. And finally, we have one decision from the California Court of Appeal involving criminal procedure and juries. The defendant in People v. Garcia have been charged with 7 counts, 3 for attempted murder and 4 for other felonies. The jury deliberated, and after a day sent the court a note that one of the jurors needed to be excused. After excusing the juror, the court asked whether the jury had been able to reach a verdict on any of the charges, and they indicated that they had indeed reached a verdict on 6 of the 7 counts. Well, the court sealed that verdict, appointed an alternate, and directed the jury to continue deliberations. They then returned a verdict on the remaining count. The defendant was found guilty on all 7, and defense counsel did not object to the procedure. But the court did not explain to the defendant what was happening and secure from the defendant a personal waiver of his constitutional right to a unanimous verdict by a jury of 12. As a result, the 4th District held that the convictions on the 6 first counts had to be reversed because of the absence of a unanimous verdict of 12. According to the court, because the trial court did not accept that verdict on the first 6 in open court with the 12th juror present, which is officially how the verdict is delivered and orally affirmed, there never was an official verdict on those 6 counts. And although defense counsel did not object, the appellate court held that a waiver would be valid only if explained to the defendant by the court, and the court has to elicit then the waiver personally from the defendant. The court vacated the convictions and sent the case back. That's it for today's Kelso Report. Have a great day in the law.